In recent years, what transgressions by employers have most often resulted in employees blowing the whistle?
Well, fraud is one of the most common. Others include environmental pollution and Medicare fraud. In New Jersey, for example, fairly recently, a whistleblower exposed the payment of millions of dollars in bills without invoices and an internal billing scheme using dummy invoices at the University of Medicine and Dentistry in New Jersey.
One would think that from the array of state and federal laws that protect whistleblowers, the employers would get the message and not retaliate against their employees. What is the downside of the employer's retaliation?
Well, a tangible downside of retaliation is a lawsuit against the employer. An intangible downside is employee distrust or disgruntlement, bad press, and if there is public exposure of an illegal activity, the recognition by members of the public that the employer could have addressed an illegal activity, but chose instead to sweep it under the rug and possibly retaliate against the employee.
Last year, there was a matter entitled Fred Brown versus the New Brunswick Board of Education. The plaintiff, who was a principal in the school district, argued that the filing of a grievance under the collective bargaining agreement constituted a protected activity under New Jersey's SEPA law. The plaintiff claimed that the suspension was a retaliation for the filing of the grievance. The New Jersey Appellate Division rejected that argument and held that the filing of the agreements was not a protected activity under SEPA. Why was this matter not protected under the statute? And what are your thoughts on this case?
In Brown against New Brunswick Board of Education, the plaintiff, a school principal, had spoken up at a PTA meeting about the treatment of female students. He was reprimanded for his comments at the PTA, and he was also reprimanded for not submitting his budget on time. He then filed a grievance, and subsequently he was suspended. The plaintiff alleged in his court action that he was suspended for filing the grievance, in which he claimed that the reprimands created a hostile work environment because his supervisor was trying to pressure older workers into retirement. The court held that the initiation of an adjudicatory process, whether it be an administrative proceeding or a complaint filed in court, does not constitute whistleblowing within the meaning of SEPA in New Jersey. And I agree that a grievance, or a court case for that matter, is not a disclosure of an illegal activity to a supervisor or a public body, and is not a protected activity under the whistleblowing statute.
Another case occurred earlier this year when Robert Wood Johnson University Hospital agreed to a $6.4 million settlement to resolve allegations that it inflated charges to Medicare patients to obtain higher reimbursements from the federal program. Whistleblowing employees from the hospital helped the federal government recover the money in 2 lawsuits filed against the hospital. The lawsuits were brought under the Federal False Claims Act. What can you tell us about this law and its relation to the whistleblower issue?
Under the False Claims Act, anyone who knowingly submits false claims for payment of government funds is liable for 3 times the government's damages plus civil penalties. The lawsuits against Robert Wood Johnson, there were 2 lawsuits, were brought under the key TAM or whistleblower provisions of the False Claims Act, which permit private citizens with knowledge of fraud against the government to bring an action on behalf of the United States and to share in any recovery.
Ellen, your experience as a litigator includes, I believe, a 10-year-long litigation in federal court in the Southern District of New York on behalf of the Custom Shop. In this case, Netis versus Levitt, the Custom Shop was sued by the operations controller of the company, who was a long-standing employee who was terminated. The employee sued under the New Jersey whistleblower statute. The controller testified at his deposition that the CEO of the Custom Shop did not terminate him in retaliation for reporting illegal or dishonest activities. Rather, the controller speculated that the custom shop's executive vice president convinced the CEO to fire him because she was afraid that she would be held accountable for the wrongdoings of the controller supposedly exposed. After the trial, the evidence supported the verdict that the plaintiff was not the victim of a retaliatory discharge. What are the issues on this case?
Well, the plaintiff had voiced numerous complaints over the years about internal matters at the custom shop that we argued successfully, and proved successfully, I should say, did not implicate a violation of a law or a rule or a regulation. The plaintiff did, however, allege that he reported 2 instances of stealing, but we were able to show that the disclosure of stealing by other employees did not motivate the termination of the controller. We showed that the motivating factor in the termination was the incompetence of the controller, not whistleblowing about an illegal activity.
Now, this case ultimately obtained a verdict for the defendant, the custom shop, which subsequently was upheld on appeal. What were the main reasons and the issues on the appeal?
Well, the jury verdict was returned in favor of the defendants, as you pointed out. Originally, the district court had dismissed the complaint for failure to state a cause of action and had also denied several proposed amendments. But after the dismissal by the district court, 2 New Jersey Supreme Court cases, DeLisa and Roach, held that an employee could state a claim under SEPA even if he disclosed illegal activities of fellow employees as opposed to illegal activities of his employer, and even if the alleged illegal practices did not implicate the public interest. So the complaint was reinstated by the Court of Appeals, the Second Circuit Court of Appeals. That was the first appeal. And then the trial ensued. After the trial, the plaintiff again appealed on the ground that the district court should have given the jury a charge under mixed motives instead of pretext, but the Second Circuit held that the plaintiff did not request the mixed motive charge. I would also add that my argument to the Second Circuit included the point that there was no evidence of mixed motive. The plaintiff had tried the case under a pretext theory and would not have been entitled to a mixed motive charge in any event.
Let me ask you a question. If your client was the whistleblower rather than the employer, what information would you convey to somehow avoid all these years of litigation?
Well, you'd want to focus on the elements of the cause of action so you're not subject to numerous rounds of motion practice, which is what happened here. But sometimes a prolonged litigation is unavoidable. For example, in this case that we've been discussing, the law changed, which enabled the plaintiff to reignite the case after we thought it was dead. But before he could do that and appeal based on the new law, he had to try his state law claims for vacation pay because in federal court, there's no such thing as an interlocutory appeal. So in part, the duration of the case was out of his control.
Well, Ellen, thank you very much for joining us today on Forensic Perspectives. Our guest today has been attorney Ellen August of the law firm Goetz, Fitzpatrick, LLP. If you have any questions on this issue of whistleblowers or any other litigation matter, please feel free to call Ellen at her office. You can reach her in her New York City office. Her telephone number is 212-695-8100. As always, our audience is welcome to contact our office with any questions or comments. Stay connected with us on the web at www.msgcpa.com, where you can also subscribe to our newsletter, Forensic Perspectives. We can also be found on LinkedIn, Facebook, Twitter, and of course by phone. Your topic suggestions for future broadcasts are always welcome. Until our next program, this is Mark Gottlieb. Thank you for joining us.
You have just enjoyed another episode of Forensic Perspectives, hosted by financial expert Mark Gottlieb. For questions and/or comments regarding this broadcast, please feel free to contact Mark by phone at 516-829-4936 or via email at msgcpa@msgcpa.com. We also encourage you to visit our website, www.msgcpa.com. The opinions and commentary in the preceding program provided by our host and guests are for informational and educational purposes only and may not be their personal or professional opinion. No accounting, tax, or legal advice is being provided. The information provided within this broadcast is not an invitation for an attorney-client or accountant-client relationship. One should always seek the advice of competent professionals to assist in their specific needs. In addition, this podcast will not be updated for changes in accounting practices or law. As such, one should not rely on any information provided by this podcast. References to resources are provided solely for the listener's convenience. We have not reviewed or verified any information, advertising, products, resources, or other materials mentioned herein. This broadcast is copyright of Mark S. Gottlieb, CPA PC, all rights reserved. Any redistribution or reproduction of part or all of this broadcast is strictly prohibited unless authorized in writing.